Member for Port Darwin.
Thank you, Mr Deputy Speaker. Mr Deputy Speaker, I stand today in support of the Bail and Youth Justice Legislation Amendment Bill 2025. But before I speak to my reasons for supporting this bill, I'd like to express, as my colleagues and those on the other side have done, my condolences to the family and friends of Mr Linford Fyke, who tragically lost his life in circumstances that have left our community reeling. Every person should be able to go to work with the expectation they will return home safely each evening. And no family should have to endure the heartbreak Mr Fyke's family are dealing with. And my deepest sympathies are extended to his wife Margaret, his children and his grandchildren, and to his community more broadly, who clearly he had such a significant impact on. I'd also like to acknowledge and thank Samara Laverty for her support for us today. She has selflessly championed the safety of our community, and her presence here as we work together to strengthen Declan's law is something I'm very grateful for. Today, our government is introducing the strongest bail laws in Australia because our community has been let down by a justice system that has for far too long placed the rights of offenders ahead of community safety. Well, no more, Mr Deputy Speaker. Today, we are putting the rights of Territorians first, the safety of our community first. Our government started this journey in October last year with the introduction of a suite of legislation, with Declan's Law, which introduced a presumption against bail for serious violent offences, mandatory electronic monitoring for repeat offenders, expanded the presumption against bail to apply to youths, and reinstated breach of bail as an offence for youth offenders at its core. It sent a message to those who choose to break the law: your actions will have consequences. And those changes, Mr Deputy Speaker, have had a significant impact, as demonstrated by the additional 600 offenders who have been incarcerated since those laws came into effect in January 25, and the 5,000 individuals who've been scanned in wanding operations. We know, however, that there is much more to do, which is why, for example, we as a government have been working on a rewrite of the Youth Justice Act to be ready for July, parental responsibility legislation, changes to the Traffic Act, and considerably more. The sad fact is, however, that while we work to facilitate change and improve outcomes for our community, we continue to deal with the legacy left us by those on the other side when they were in government. A situation where, as happened the day after the tragedy in Nightcliff, young people, thinking it was their right, chose to rampage through our CBD, creating havoc for shop owners, pulling stock off shelves, abusing and threatening workers and patrons, daring retailers to remove them from their stores, with one young person revealing she was carrying a small-edged weapon and threatening harm, clearly confident she could act with impunity and total lacking in any concern there would be a consequence for her behaviour. And sadly, she was right, as the group absconded before assistance arrived. This group of young people were not hungry or destitute or homeless, as implied by the member for Goytcha, that to participate in such behaviour they must surely be. They had simply intended to create havoc and harm and fear into our community members, simply because they could. And this type of behaviour, Mr Deputy Speaker, does not happen in a vacuum. It develops over time in an environment where a clear message has been sent. You can do whatever you want and there will be no consequence. Mr Deputy Speaker, I was pleased to hear the member for Goytcha say in this chamber today that this behaviour, no matter the reason, can be addressed. There are solutions. But I say in return, Why did you not take appropriate action when you had the opportunity to do so? The member for Goy just spoke of innovation and looking to address root causes and change behaviour. And he was absolutely right, Mr Deputy Speaker, that's critical. But those actions of innovation, addressing the root causes, were not taken. If they were, why were programs that were not demonstrating outcomes allowed to continue unabated? One that comes to mind was the safe sleeping program that was established in Alice Springs when those on the other side were in government. When I reviewed that program, funded at a cost of $500,000 per annum, I found only one young person had been placed in that program in the first quarter of 24-25. Innovation is about doing things differently, not throwing good money after bad. And that's why I worked with the Department of Children and Families to deliver the Circuit Breaker program, a program that is having real results on the ground where it counts. In 4 short months, this program has worked with young people at risk and their families to give those kids the best possible opportunity to succeed in life. Its success is demonstrated by just how rapidly families and young people are engaging with this program. For example, Mr Deputy Speaker, at the beginning of April, there were 120 young people in the Circuit Breaker program, with 75 of those having an active family responsibility agreement in place. Today, a short 3 weeks later, that number has grown to 136 young people, with 85 family responsibility agreements in place. 35 of those young people are now actively engaged with school attendance officers. And for comparison, in the 5 years from 2019 to the implementation of the Circuit Breaker program under the previous government, only 60 family responsibility agreements were entered into. 60 in 5 years, and we've seen 85 in 4 months. Families see the Circuit Breaker team as trusted supporters for them as they work to get their kids on track. I've personally been out on the road with the Circuit Breaker team in Alice Springs twice now and seen firsthand how they have connected with the community, working with families and kids. I've heard the success stories of young people who've been discharged from the program because they are back at school, or more excitingly, they've been able to find a job, or they've been placed into a family situation that is safe, significantly reducing the risk they will progress down the path of antisocial or criminal activity. Most exciting, the Circuit Breaker team are full of hope and see how their actions are having a positive impact in the lives of kids who until relatively recently were heading down a path that mostly would have seen them end up before the courts. But these are early days. The signs are good. The next step, once changes to the Youth Justice Act come into play that make diversionary programs mandatory as opposed to voluntary, this will provide us another layer of intervention where a firmer consequence may be needed. This is innovation. This is facilitating change and improved safety outcomes for everyone in our community. Madam Speaker, the member for Nightcliff noted, Mr Deputy Speaker, the member for Nightcliff noted that young people, or that people generally on remand don't receive rehabilitation programs. And the serious backlog in the court system, which was mentioned earlier in this chamber by my colleague, the Attorney-General, is a legacy of a time those on the other side were in government. And that does mean that in some circumstances, by the time a person on remand's case comes before the courts and is decided, that person may indeed be released for time served on remand. When this happens, Mr Deputy Speaker and member for Nightcliff, that you're absolutely right. A person on remand, if found guilty when their case goes to court, may very well exit the judicial system, not serving any time in a correctional facility, and by association of having been on remand, not having been provided access to any rehabilitation programs. As the Minister for the Prevention of Domestic, Family and Sexual Violence, this immediately flagged to me as an issue. Why didn't we have the capacity to deliver programs to those on remand, especially if we consider the importance of early intervention in changing behaviour of the perpetrators of domestic, family and sexual violence? Well, the obvious challenge is that rehabilitation programs are delivered to those who have been convicted of a crime. And under the previous government, no steps had been taken to see if there was any capacity to create programs that people on remand who under law are not guilty of a crime can be mandated to attend. Mr. Deputy Speaker, it's a challenging area, but it's a discussion I have been willing to have, and I'm currently working with my colleague, the Attorney General, to determine if we can create a process where we can deliver programs to those on remand in a way that doesn't jeopardise the case that they have before the courts. I don't know at this point in time where the exploration of this will land, but I'm 100% committed to working to ensure that where there is an opportunity to deliver support and programs that will decrease the risk of domestic family violence in our community, we will take them. And this brings me back, Mr. Deputy Speaker, to why we are here today. We are here today to say we will not resile from the hard decisions. We will work to do everything we can to make our community safer. As so eloquently said by one of my constituents, safer today, not tomorrow, not next week, not next year, but today. Our government's preparedness is a matter of urgency to strengthen the tests that determine if an offender is granted bail is evidence that we agree with my constituents' sentiment. The bill before the House today, as I said earlier, further strengthens the amendments to the Bail Act made in October 2024 through Declan's Law, and very clearly puts on the table that the safety of our community must be considered before all else. Thank you, Mr. Deputy Speaker.